Something just happened at the United States Supreme Court that could completely reshape the future of gun rights in America. And most people have no idea it even happened. In an 8-1 emergency order, the court quietly blocked Missouri's Second Amendment Preservation Act from taking effect, sending the case back to a lower court, while powerful forces inside the federal government make moves behind the scenes. But here's the part no one is talking about. The Trump DOJ made a promise to the court that could either save this law or bury it for good. And so far, that promise hasn't been kept. In this video, I'm going to break down exactly what the Supreme Court did, why it matters to every gun owner in the country, and what could happen next, because this fight is far from over. The Supreme Court just dropped an 8-1 emergency order that could permanently change how states are allowed to defend the Second Amendment. And almost nobody is talking about what this really means. A case that was supposed to protect Missouri's Second Amendment Preservation Act has now been sent back to a lower court. But behind the scenes, the Department of Justice may be setting the stage for something far bigger. Depending on what happens next, this could either restore state power over federal gun enforcement or quietly erase one of the strongest pro-Second Amendment laws in the country. Here's what actually happened. In a case involving Missouri's Second Amendment Preservation Act, the Supreme Court issued an 8-1 emergency order refusing to block a lower court injunction that currently shuts the law down. That means Missouri's SAPA remains frozen, even though the law was designed to prevent state and local officials from helping the federal government enforce gun laws the state believes violate the Second Amendment. Justice Clarence Thomas was the lone justice who wanted the law temporarily restored while the case continues. And instead of taking the case up now, the court The Supreme Court issued an 8-1 emergency order denying Missouri's request for a stay on a lower court ruling that blocked its Second Amendment Preservation Act, SAPA, a 2021 state law aimed at preventing local enforcement of certain federal gun regulations. Only Justice Thomas dissented, while the majority, including conservative justices, refused to reinstate the law during appeals. This shadow docket decision underscores limits on state nullification of federal law under the Supremacy Clause. Case background. Missouri's SAPA declared various federal gun laws unconstitutional within the state and barred state officials from enforcing them, imposing $50,000 fines on violators while allowing residents to sue cooperating officers. A federal district court struck down the law entirely in favor of the Biden DOJ, citing Supremacy Clause violations. The Eighth Circuit upheld this, viewing state non-action as impermissible interference. Missouri sought Supreme Court intervention twice, first denied 8-1 in 2023, then again recently after Eighth Circuit affirmance. Key ruling details. The court denied certiorari or a stay, sending the case back to lower courts without full briefing or oral arguments. Justices Alito and Gorsuch concurred, noting the injunction targeted enforcement rather than invalidating the statute outright, potentially preserving narrower non-cooperation elements under anti-commandeering doctrine. The Trump DOJ, while opposing broad invalidity, conceded the prior nationwide injunction went too far and pledged to narrow it on remand, but has not yet acted as of late 2025. Implications for gun rights. This order limits aggressive Second Amendment sanctuary laws by distinguishing permissible state non-enforcement, protected by cases like Prince versus United States, from outright nullification, which the court rejected even from pro-gun states. It affects over a dozen states with similar laws, signaling risks for penalties or resident lawsuits against cooperation, though.